One for State of Kansas versus Joshua Evan Stohs. Well, as you're settling in, I would like to express the court's appreciation for your flexibility, and we did change the time of this argument from 10:30 to 9 o'clock this morning, and council were very accommodating in that. We appreciate that. Thank you.
That's no problem, Your Honor. As someone who's finishing up paternity leave, this gets me out on the disc golf course a little bit earlier even, so. May it please the court? Police stopped Joshua Stohs for walking down the wrong side of the road. When asked his name, Mr. Stohs told the officers his name was Joshua Greenmore and produced a social security card for Mr. Greenmore. Not believing Mr. Stohs to be Mr. Greenmore, officers arrested Mr. Stohs with the intent to book him into jail as a John Doe, but Mr. Stohs revealed his identity at the jail. Mr. Stohs was indicted on one count of identity theft, the state's theory being Mr. Stohs used Mr. Greenmore's personal identifying information in an attempt to attain the benefit of not being arrested on outstanding warrants. Mr. Stoh's theory of the case is that he did not intend to defraud Mr. Greenmore or anyone, and that he only committed, that he did not commit identity theft, but committed interference with a law enforcement officer. Pursuant to 21-5109D, Mr. Stohs could only be sentenced to the more specific crime, interference, and the Court of Appeals erred in finding otherwise.
How does he get sentenced to a crime that wasn't even charged or convicted on? How would that work?
Correct. So when we look to the past cases that the legislature modeled 21-5109D on, particularly Williams, what happens is once the defendant brings this up to the district court's attention, it is on the district court to determine what is the more specific crime. And particularly here, even though his conviction was for interference, after all the evidence is in, the district court is in a position to say, no, the specific crime here is interference, and sentence them to the terms of that crime.
So the district court has an obligation to amend the complaint and add a charge?
Or dismiss the complaint, as what happened in Williams and in I believe in Williams. In Williams that occurred. That also, I'm blanking on my other cases, but we also see this in Marlon Williams when we discuss this. Reed and Wilcox they also discuss, because when the rule is discussed by this court in pre-Euler, and at the time it's being modeled, 21-5109 is being modeled off of, the general specific was spoke of as a charging rule, that the state can't charge this, that the defendant can charge this. Now, it has been reached for the first time on appeal, but the fact of the matter is when Mr. Stohs informed the district court, no, this is not interference, I am guilty, or excuse me, this is not identity theft, I'm guilty of interference of a law enforcement officer, that put the ball in the district court's position to make sure that the more specific crime was in front of the jury as the legislature and the statute require.
So in your view, it raises no due process concerns, or is it more accurate to say that there's a waiver essentially of any due process concerns because your client wants the more favorable sentence?
The due process is tricky because I understand that there is a sword could cut both sides on this one, to where a person could get convicted of a lower penalty, more general crime, but then later on at sentencing state could be like, well, hey, this is more serious crime. I think that would provide a due process problem because the defendant is the one that has to be on notice of what they're defending against and what they're facing. But one, the due process doesn't cut towards the state. And two, the state, as the person in charge of the charging, ought to be responsible for picking the most specific, most appropriate crime to begin with. But if they don't, this is an opportunity for the defendant to get that most specific crime in front of the jury and to fulfill the legislative intent of 21-5109D.
On that
Go ahead.
on that statute, how would you articulate fitting these two crimes into that statute you just referenced, the statutory definition of general and specific crimes?
Yes. So when we look to general specific, because remember, when the legislature codified the general specific, the note from the codification committee was that they were attempting to talking a little bit faster, I'm gonna slow down here, that they were attempting to codify this court's precedent as stated in Williams.
Well, I don't want to focus on that. I just want to look at the statutory language, and what I'm looking at is that what the legislature said is that general and specific are crimes that differ when one is defined to prohibited a designated kind of conduct generally, and the other defined to prohibit a specific instance of such conduct. So it seemed to me that you would have to say that identity theft is what? That's somehow interference with a law enforcement officer is like, I just don't
Yeah.
see the
And
connection.
I understand, but I think the key word there is the conduct, because when we look at other cases, when we looked at Marlon Williams, now there are two Williams in these cases, which is confusing, but the 2014 Williams, Marlon Williams. Now there, the general specific test was negated because this court found he was actually charged with a specific crime, and the crime that he was complaining he should have been charged with wouldn't have captured the full gravitas and the full actions of what he did. So we focus on the conduct of the defendant. Now, if we're focusing on the strict elements test and one crime is always going to be the other, then we're in identical offense territory. But when we focus on the conduct of the defendant and we look at Mr. Stoh's conduct here, his conduct was using personal identifying information, which fits the category of any false information, but the specific benefit, because identity theft is for any benefit under the sun, anything you can think of, whereas interference is a very specific benefit to impede the duty of the officer. So here, when we have a category of information
So
that fits,
interference with a law enforcement officer is the only reason the legislature passed that is to prohibit a specific instance of identity theft.
I
I don't
think-
understand that.
no, that when somebody gives false information to police to avoid arrest, that is interference, regardless of whether or not the information given is personal identifying.
I understand that argument, but I just maybe we're talking past each other. I just couldn't conceptualize how that fits the statutory definition.
Again, I think because once we're looking at the conduct, which is why we need to know the facts of what's going on, you can't necessarily do this from the complaint. You have to know the underlying facts so you can say which crime is more
Well, the
specific to the conduct.
this will be the last question I'll ask, but the statute says that the specific crime is defined as prohibiting a specific instance of such conduct. And the such conduct we're talking about here is identity theft. So that it just strikes me that your argument has to be interference with a law enforcement officer is a specific kind of identity theft.
I think that once somebody gives information to a law enforcement officer to receive the benefit of not getting it, basically, anytime you give a false name to the police, you are committing interference. Now, the only difference between interference and identity theft in that case is whether or not the name turns out to be real. And in fact, so let's say I get pulled over by the police. I have a warrant out, which I do not, and I would not be here if that were the case. But let's say I get pulled over and I don't want to go to the jail. So I think of the most generic name I can think of off the top of my head. And I say Will Smith. Well, the famous rapper, actor, probably not going to be too happy about that. And the fact of the matter is that even though I was intending to create interference, I did not want to defraud anybody, didn't want to take Will Smith. The fact that I just made up a name and it turned out to be a real name isn't even a defense to interference. So we're getting to this place to where the only difference between interference of a law enforcement officer for giving a wrong name and identity theft is whether or not the name corresponds to a real person, regardless of whether you even knew that or not.
Here, there's an additional fact that he handed a social security card, and doesn't that make a difference in the conduct in satisfying the identity theft? That's a difference here between your scenario of just throwing out a name.
Sure, but I also think that that's a little bit of a red herring because one, whether or not he had the social security card, he's still just as guilty of identity theft because using a name or even a place of employment or even a screen name is enough for identity theft. So even if he did not have the social security card, this identity theft is still there. And on top of that, the gravamonte of identity theft isn't the possessing or the using of the personal identifying information. It's for the personal benefit. And any benefit is an incredibly broad category, but the gravamonte here, the exact benefit is a very specific type of benefit to impede the arrest. So in that case, yeah, this is clearly the more specific because the benefit is what we're looking at here. And the information can fit both categories, but the specific, the benefit, and again, without any intent to get a benefit, there is no identity theft. I can carry on someone,
It seems that you're slipping from conduct to something other than conduct when you talk about the benefit. And you've been arguing that what we need to focus on is the conduct. Do you understand what I'm saying? I mean, to me, it seems
yeah.
like the language of the statute is more like, I commit identity theft, and there's this generic statute about identity theft. But then there's another statute about identity theft when I use a passport. And that is a more specific conduct than the more general, I can commit identity theft in a multitude of ways.
Sure, and I understand that those are the easier cases, you know, I mean, those are the very clear cases, but I think what the legislature is trying to do by going back to Williams is to make sure that the state is charging the most specific, most appropriate crime.
So get us to Williams.
Yes,
We don't get to Williams unless we find that statute to be ambiguous. Correct?
no, well, it depends, because I understand, you know, the general way this court seems to do statutory interpretation is we start with the plain language, and then if we can find an answer from the plain language, we're done. Now, but I think the problem is that if we're consulting the plain language when we know what the legislative intent is and the legislative intent to codify Williams, we can't look to the plain language while ignoring that legislative intent because
We've got several cases that say we can.
again,
Because it's so hard to, you know, the words are the words.
the words are the words, but when we have the legislature saying, hey, we want to codify this case law and we're using these words to do it, I think the legislature is telling us what they meant to say. And as interpreters of legislative intent, we can't turn a blind eye to that because then that's just essentially overruling what the legislature tried to do. So when we don't know what the legislature is trying to do and we have sketchy legislative intent or we don't know, then obviously the plain language, but we are here to interpret the laws that the legislature made as they intended to make them. And so if we know what the legislature tried to intend, I think we have to read the plain language with that in mind, or else we're just running roughshod over the legislature.
And is your plain language, I'm getting a little bit mixed up, but is your plain language saying that once a defendant brings up a more specific crime, the court has the duty to make sure the specific crime is in front of the jury?
I think if you get the chance before, then yes, but also, so going to the plain language of 2159 OD, we got an A and a B. I read those as setting out two separate rules, one as a rule to prevent somebody from being convicted of a more general crime in lieu of the specific. And the second one that in case that happens, the defendant can still make the showing or bring it to the attention of the court because it doesn't say the conviction, it says that you are sentenced to according to the terms of the more specific crime.
I see. I mean, I understand all your arguments and I understand that if both of these were charged, where I'm hung up is how do we even get there? Because the statute is, I mean, we've got a separation of powers issue here. The statute gives the prosecutor prosecutorial discretion. The defendant may be prosecuted. That's under 2150-109A. The defendant may be prosecuted for each of such crimes. This is not a court decision. The court doesn't decide what statutes are being prosecuted. And I don't see from the plain language of this statute, I don't see any ambiguity here saying, I mean, it does not give the court any authority or duty or anything to make any kind of.
But this is where we have to look at what the legislature did and when they cited to Williams and passing this, because sure, 215109A.
Where in here are we even, as the chief said, where in here are we even going to what the legislature cited in Williams? I mean, it's clear here that this is, you can't be, the whole point of this is, if you're charged with two, you got to be, sentenced to the lesser. Where does it talk about, and if you're only charged with one, and a defendant brings up another, then the court has the duty to make the more specific crime in front of the jury.
Because we see this in Williams itself, because in Williams, the defendant was only charged with one crime. He filed a motion to dismiss. The district court said, yes, the crime that you are not charged with is the more specific. Your aggravated indecent liberties with a child is dismissed because aggravated incest is the most common. So when
The procedural history here was there a motion to dismiss filed?
Mr. Stohs was charged via indictment, so he didn't get a preliminary hearing to see the evidence before. But at jury trial, he requested for the court to tell the jury that he was guilty of interference with a law enforcement officer and not interference. And then at sentencing, when the second part could have kicked in, Mr. Stohs himself said, I did not try to impede, I did not try to defraud anybody. I didn't try to steal information, but I probably did impede. So the district court had the information. And when we look to, this is why we have to take the legislative intent into effect, because this subsection 215109D was meant to codify the procedure and the law as stated in Williams. Williams is only charged with one crime, which allowed this to happen. So we have to look at in that route. And as far as 215109A, 215109A sets out a general rule, but B, C, D, and E limit that general rule and provide exceptions to the prosecutorial discretion. But at the end of the day, the legislature was trying to ensure that people were charged with the most specific, most appropriate crime and not novel applications or, suspect applications of different general crimes.
I think the key there is you say are not being charged because the charging is in A, but everything else is convicted.
Right, which means the defendant can bring this problem before the conviction or under B, even afterwards, after the evidence is in, and say, hey, look, this evidence satisfies the more specific crime. I can only be sentenced according to the terms of that crime.
Right, and maybe a judgment for acquittal at the,
We had judgment for acquittal, it got denied. And that's that's the problem with specific general, right? I can't deny that there's sufficient evidence for identity theft because the benefit is so much broader. It's when we look to what the actual statute is trying to prohibit, which in this case, interference is impeding of the duty. That's where the problems go. That's why you can't really raise a sufficiency issue to these things because they fit, because one is more general and it's like a funnel. I'm trying to argue that we should be sentenced down here. Well, naturally, everything else is gonna fit when we go up the funnel, correct?
I want to return to our discussion about conduct versus mens rea, because I think what you're focused on is mens rea, not conduct. If you look at the two statutes, the identity theft is obtaining, possessing, transfer, using, selling, and purchasing identifying information. It has nothing to do about a false report to a law enforcement officer, which is the conduct that's involved with interference with a law enforcement officer. And so if we focus on conduct, as you argue, is the focus of the statute, there's no overlap there. You get to the overlap, as I understand it, by arguing where the intent was on the mens rea, but that's different than conduct.
Well, no. No, excuse me. So the way I look at this is that yes, the subsection A of identity theft says that identity theft is doing these things with the personal identifying information, right? But having this information alone isn't enough. It's what you do with it. So if I was walking around with somebody else's social security card or even just trying to return it to them.
No, it's obtaining.
Yes.
What your client did, possessing what your client did. And then, there are other things which include using.
Sure.
But I don't remember that the charging document was specific to, the laundry list.
Right, but I will say this. One, we don't know that Mr. Stohs obtained the document with intent to fraud. He had it, but we don't know why he got it or how he got it. We don't know why he was possessing it.
That's sufficient, but to your point,
No,
that's sufficient.
Sure, I know, but the only thing that works, that they proved, is using. And using that information when you give to law enforcement officer is giving false information to law enforcement. It's the same. So the conduct is the same, but what makes the crimes, what makes these actions crimes is the intent. Now, an identity theft, so the way I look at this is that you have an identity theft, you have a narrower universe of information, right? Now, the information itself is not the crime. It's what you do with that information. Now, again, the same thing with interference, except you have a much larger universe of information, any information, right?
under your theory of this case, had Mr. Stohs pulled out a gun and shot the arresting officer, you could come argue, oh, more specific, he interfered with duty of a law enforcement. Like, how is that any different?
No,
Or
I mean, I
your
think-
theory of the case.
I mean, I think in that crime, the more specific case or crime would obviously be, battery on a Leo, ag battery on a Leo.
Why is that obvious?
Because he didn't give any information when he shot him. He gave him a bullet, but he didn't give any information to impede the arrest. He just shot him and ran.
I just think the argument that you're making here could be made equally with those two different statutes.
I mean, unless,
Because let's say it's battery or whatever, like that's a broad, you can batter a person in a lot of different ways. But it's more specific if you batter a law enforcement officer in order to avoid arrest.
right. No, exactly. And in that case, if you're charged with normal battery, that would be the
So you
incorrect.
do think it would apply in a battery situation?
If we're dealing with battery and battery with Leo, but here, again, I think if I can finish my point about the broad narrow. So with the identity theft, we have narrow information, but then we go into this broad any benefit, right? Now, again, the information isn't criminal itself. Now, interference with the Leo, reporting any information, broad, but reporting any information isn't the crime itself. It's the purpose you do it for. So in interference, in identity theft, we have very narrow information, way up any benefit, right? Now, interference, we have any information, impede arrest. Now, when the information fits into both categories, and neither one of those is criminal on its own, you have to look at what you do with the information, and interference in this situation is clearly the more specific crime.
One last question from me anyway. As I reviewed this, I noticed that, well, let me start with this. My understanding is your request is that your client be resentenced to, interference.
The way, I understand the case law, I think that's the proper remedy. As I was getting ready for this argument, part of me is wondering if I asked for the wrong remedy. I don't know if the answer should just be to vacate his interference. But the way I read the statutes, I think the proper remedy would have been for him to only serve the term for the more specific crime.
And as I looked through things, I noticed that he was sentenced in August of 2021 to 18 months.
Right.
So that's sentence.
No, yeah, that sentence has been
long
long
gone.
served, yes.
So is this moot?
It is, it may be moot as it relates to Mr. Stowe's sentence, but as a matter capable of repetition and able to avoid review, because remember, identity theft's only a level 8 and interference is only a level 9 at worst, if not a misdemeanor. I don't think this court, if we have this interplay again, would really get a chance to look at this problem, given those sentences.
Will it affect his criminal history score?
If his, I would have to look. I don't believe so, because I believe he was a criminal history A, but I have sentencing at counsel table, and I can check that out and answer
But I
that.
mean, in future cases.
No, I believe he's already in A. Yeah, so it should not.
Plus, as I understand, you're not asking for a new conviction. You're just asking for a different sentence.
At the time we were, but as time goes on, it's tough to switch remedy midstream in an appeal. But I do think that this court, particularly in light of Euler, I think that clarification is needed on this statute. And so that regardless of whether or not this has any impact on Mr. Stowe's personally, I think that it does meet an exception to mootness as capable of repetition and question that needs to be answered by this court. I have no more presentation. I'm more than happy to answer any questions. But if not, I will sit down and turn the lectern over to my colleague. Thank you.
Good morning, may it please the court. The state appears by Deputy District Attorney. The state's position here, as I think the court has already hit on, is that, well, the Court of Appeals got it right, and that this statute doesn't even apply when the state charges one count of something and not two. When we don't have two convictions under the plain language of the statute, this doesn't apply.
And what language are you focused on when you say that? Is it the may not be convicted of the two crimes in one, in some part one, D1?
Yes. Yes, Your Honor.
And you think that carries on to D2?
Yes, I think it's, well, there's an and there.
There
So
is an and there.
we have to have you know, whatever's in subsection 1 to get the sentencing relief. So, and the state didn't even brief whether you can get sentencing relief on something that you weren't charged for, which I don't know that you can. If you're not charged and convicted, I don't know that you can get a sentence for a different crime, but we didn't brief that. But yes, our point would be the legislature very specifically said may not be convicted of the two crimes based upon the same conduct. And then there's that and. So when we don't have two crimes that were convicted of, that the defendant was convicted of, this doesn't even apply. And I think that that kind of goes along with the prosecutorial discretion that we've been talking about. There are other subsections of that statute which limit prosecutorial discretion, just like this one does. And we can charge multiple crimes. We just can't convict and sentence on them both. That's when it becomes the problem, like in multiplicity.
But it seems strange then that you'd have that statutory scheme, yet you could avoid it all just by charging the more general offense. You know what I mean? It's like, it seems to me that the legislature's really directing that the discretion be towards the more specific offense. It should be the charge and the sentence. But it sounds to me like your interpretation would allow a prosecutor to sort of avoid that all and just by charging one offense and choosing the more general offense.
I would agree with that. I mean, I think there's no limitation on if there are a set of facts that apply. I think this court has said when there are two statutes that it applies to, that the state can do that, and we have discretion to do that.
Except when it goes on in the statute to really direct that a preference towards a specific crime be charged and convicted in the exercise of that discretion. Why couldn't the statute be read that way? I guess,
I guess the state
as a
does-
limitation on charging discretion.
I guess the state doesn't read charging in that because the legislature, I mean, because the language of the statute says convicted. And they could have easily just put may not be charged or convicted.
It
And we
does
don't
say
have that here.
shall be sentenced. Admittedly is not directed at the prosecutor. Shall be sentenced according to the terms of the more specific crime.
Yes, which doesn't trigger until we have the convictions for both.
Oh, but where do you get that from the language? That there's two convictions,
May not be convicted of the two crimes.
right? And then it says shall be sentenced according to the terms of the more specific. So you think reading those two together, I guess your argument is that this only applies if there's two convictions.
Yes. And if we look at some of the other case law, I think there's a couple of opinions by the Court of Appeals. I think they're unpublished, but since this statute has been enacted, I think the majority of cases have dealt with situations where the state has charged identity theft and criminal use of a financial card or child abuse and aggravated battery. And they've had similar challenges to this. And the Court of Appeals, I think the defendant got relief on the identity theft and criminal use of a financial card, saying that criminal use of a financial card is the more specific offense. So you can't be sentenced on both and when you're convicted on both crimes. So I think there have been appellate court decisions that have dealt with two charges, two convictions, and then deciding whether it's general versus specific.
I assume you think we don't need to decide necessarily that issue, do we, to resolve this appeal? If identity theft is not fit within the more specific subsection D of that statute, right?
If
We don't have to decide whether this applies only to two when there are two charges. If we go ahead and find and we can determine on the merits that interference with law enforcement officer doesn't fit into subsection D.
I think this court could avoid the question, of what triggers the rule and just find that, and we did argue, and that's what I argued in the brief, is that interference is not the more specific. So I suppose this court could, but it is an issue that the court has avoided in other cases, so it might be nice to have some guidance on when that rule is triggered. But yeah, I suppose this court.
What
could
would have
decide.
happened if you had charged both crimes, interference and identity theft? Would we still have two separate sentencings?
If we would have charged both and convicted on both, I think he
Right.
could have made this argument and then the court, this rule would be triggered because we have two convictions for the same crime based upon, or I'm sorry, two convictions, convicted of two crimes based upon the same conduct. And then the court can get into the general versus specific analysis. And if this court found that interference was the more specific crime, then he would get relief. But again, we just argue that this is not the more specific crime. And as we laid out in our brief,
Well, if
we
it's
don't-
not the more specific crime, then why? Just what you said, why couldn't he be sentenced for both? It doesn't fit in the statute.
I think he could, I mean,
I thought you just said no, then they're kicking the analysis. It just seems to me your position is there are two separate crimes. He could be sentenced, he could be charged, convicted, and sentenced on both separately. Is that your position?
yes, because, well, then that kind of goes up to the top part. When crimes differ only in that one is defined to prohibit a designated kind of conduct generally, and the other to prohibit a specific instance of such conduct. So if this court found, no, there's no general versus specific, these are two different
Right, that-
statutes, yes, then he can be sentenced on both.
Thank you.
Let me ask you a question. There's prosecutorial discretion, obviously built into the statute, but have we crossed into, arbitrary enforcement, with the charging documents? Let's say from, I mean, really, there doesn't seem to be any right, I mean, assuming how you answered Justice Rosen's question, assuming we disagree with that he couldn't have been convicted and sentenced to both because it's the same underlying conduct. I mean, how do we deal with a prosecutor that always overcharges in one instance and then a prosecutor who doesn't in another instance?
I mean, I think there are, as set out in 215109, there are, limits to prosecutorial discretion. And if, two statutes fit, if facts fit two statutes and the state believes that they can meet its burden to prove beyond a reasonable doubt, I think the prosecution has that discretion.
I don't
I don't
think
know
that-
that it's the court's job to come in and determine what the state can and can't charge.
Well, there's no limit on the prosecutor in 5109, right?
Well, it sets out certain things that the prosecution can't do, certainly. I mean, defendant cannot, I think it's E, you can't be convicted of both a greater
not-
and a lesser.
Right, well, that's not something on the prosecutor. That's just saying that the jury or the court can't convict.
Well, I suppose they could charge them with both.
Right,
So that doesn't limit their charging ability, but they
Right.
can't be sentenced.
right.
Oh.
So, I mean, that's not a limit on the prosecutor. There's no limits on.
I mean, I guess I would just go with, I think there's case law that says that there's the prosecutorial discretion that the state has is not to be, I don't know the right word for it, but I don't know that this court's has authority to question that.
Would you agree, going back to Justice Paul's earlier question, that effectively eviscerates subsection D? I mean, as soon as this court pronounces a ruling that one crime is a more specific instance of a second crime, like the memo goes out to prosecutors across the state, don't charge these together. Only charge the more general crime, never charge the specific, right? And there'll be nothing wrong with that.
I mean, yeah, I think possibly in that Court of Appeals case where they said, hey, you can't be convicted of identity theft and criminal use of a financial card. Look at your facts and see which one, if it covers both, then you have to be charged. I think the prosecution would charge them with the more specific
Why?
offense.
Why would the prosecutor ever do that? I don't understand that.
Charge them with the more specific offense for the facts that, I mean,
Doesn't the prosecutor want to? I mean, I'm not attempting to malign prosecutors here, but just from the perspective of you want the strongest case you can bring. And if the law permits you to seek conviction under the general crime, so long as you don't charge the specific crime, why wouldn't you do that?
I suppose we can.
So it does eviscerate
I mean,
subsection D.
I don't know that it eviscerates subsection D because subsection D has that specific language of it cannot be convicted of the two crimes. So,
Or
I mean,
sentenced.
may, but it may not. I mean, it's just a may not in that use of may in that one and shall into is interesting, I guess.
So the second
basically.
crime-
So,
Second crime may merge with the first crime, or if there are two convictions and you can only have one sentence, then you have to do something with that second conviction. It may go away, it may be reversed, it may be merged, but the sentence has to be of the lesser.
Well, the sentence has to be of the more specific crime. That doesn't necessarily mean it's a
Or-
lesser
or
punishment.
more specific, true.
Yeah, so I mean,
Could be a lesser.
the more specific crime could have a greater punishment. So I don't know that, yeah, I mean, I don't know what happens to the other conviction. What the Court of Appeals did in that case, or what the district court does when they find that one's more specific than the other. But certainly they can't be sentenced. Well, they can't be sentenced according to the terms of the more general crime. They have to be sentenced to the more specific. I don't know that I have any further presentation for the court.
questions? Do you have a position on my question about whether this is moot?
You know, Your Honor, I didn't file a change of notice of change in custodial status. I'm not sure when I know he was released, but I'm not sure when that lined up with when the case was docketed. But since this was framed as a sentencing issue, I think this court could find it moot since he has served his sentence, although I'm not sure about post-release time, if that counts.
I think that's important too.
So, and I didn't look up whether he was still on post-release, but I do believe he is no longer serving the prison portion of the sentence.
Thank you, Your Honors. And a shocking twist, I actually don't have anything else to say, unless this court has any questions. I would just ask that this court reverse the Court of Appeals, and thank you very much. Appreciate it.
Court will take this matter under advisement.